Good evening, everyone.
Good evening. Yeah.
Welcome. My name is Tracy Linfield, and I'm the recently deployed new director of the Mandela Institute, which is a research center affiliated to the School of Law. I'm joined in welcoming you by the co-hosts of this event, which are the Southern Center for Inequality Studies, headed by Prof Eleanor M, and the Mind Institute, which is the Machine Intelligence and Neural Discovery Institute, headed by Professor Benjamin Rossman, who incidentally was nominated by Time 100 as one of the most influential people in AI. We gathered this evening to imbibe in the wisdom of Professor Eleanor M. The advertised title of this talk was Regulating Dominance for a Tech-Driven Economy, Reflections on Comparative Law. But the title of Prof. Fox's slides, which you can see, which he's graciously shared earlier this week, is a more colloquially catchy, big tech, big data, and the big challenge to the world. So you're in for a big treat tonight. We had, sorry, I have to kind of toggle my glasses because you're all fuzzy for when I put my glasses on. We've had an overwhelming response to this event, more than 160 RSVPs, including a sizable contingency from the Competition Commission, members of the bar, leading law firms, Bowmans, Cliff Decker Hoffmeyer, Norton Rose, Anderson, Fasken, Herbert Smith Freehills, represented from the Reserve Bank, labor union reps, civil society and consultants, many colleagues from Wits and other tertiary institutions such as UNISA and UJ, and then a very special welcome to Prof. Bronstein's competition law class. Okay, data protection class. Well, a class. Data protection, the other half, which are online mainly, and those are our future leaders. So I'm very pleased that they could join us this evening. If I may introduce the panel, to my right, Prof. Imran Valodia is the Pro VC of the Southern Center for Inequality Studies. He was previously the Dean of the Faculty of Commerce, Law and Management, and he currently serves part-time on the Competition Tribunal. He has recently been appointed to the Stiglitz G20 Extraordinary Committee of Independent Experts. Next to him is our guest of honor, Professor Eleanor M, who is a Professor Emerita at New York University School of Law. She's known for her work on antitrust and economic development and the special needs of developing countries for economic law attuned to the nation's context. And Professor Fox, people in the global south need friends in the global north like you. Next to her is Ms. Yasmin Karim, Professor Yasmin Karim, actually, visiting adjunct professor at the University of Wits. She is a former member of the Competition Tribunal and occasionally acts as a judge in the Gauteng division of the High Courts. Rounding up the panel at the end there, Professor Jonathan Claren, a Wits professor and expert in constitutional law and human rights. He heads up competition law teaching at Wits. He's published extensively in this area and recently worked on the National Advisory Council Against Corruption. And last, but very much not least, we have Mr. Derek Lotter, who's the co-head of competition law practice at Bowmans. Derek has more than 20 years of competition law practice. He has been involved in prominent competition matters in South Africa and on the continent, and he's advised both corporates and governments. So that is our panel for this evening, everyone. So I'm very pleased. I have a curious mixture of joy and gratitude that an event of this nature would come so soon into my new tenure, and its alignment with the trajectory of the MI is perfect. You will probably know that Nelson Mandela's given name, Rolihlahla, meant to pull the branch, which meant to disrupt. And that is essentially what we're going to be doing this evening. We're going to be participating in an act of disruption. So may the disruption begin. If you hand over to Yasmin, who will move us along in the program.
Thank you, Tracy. You can make your way to the podium. I'm just going to talk a little bit about you, Eleanor. Thank you, Tracy, and congratulations on your appointment to the Mandela Institute. And good evening, everyone. A warm welcome to our panel and our esteemed guest. I thought I should just remind ourselves about Eleanor's achievements and for us to enjoy this session, which Simpson, Thatcher, and Bartlett. In 1970, she became the first female partner at that firm and was one of the first female partners in a big Wall Street, New York law firm. In 1978, she served on President Carter's National Commission for the Review of Antitrust Laws and Procedures. And as if that wasn't enough, from 1997 to 2000, she served on President Clinton's International Competition Policy Advisory Committee of the US Department of Justice. For those of you who might not know this, Eleanor has provided wise counsel to many governments and agencies, and they still beat a path through her door. She holds a special place for South Africans, not only because she was an advisor to our first democratic government in 1997 on matters of trade and antitrust, but also because she has been a friend for more than 20 years, or sorry, more than 25 years, and maintaining an avid interest in the development of our country. She avails herself whenever needed by government, academia, civil society, and practitioners alike. Please join me in welcoming Eleanor. Thank you, Eleanor.
So thank you, Yasmin, and thank you, Tracy. That was just too nice, but thank you anyway. And I'm just going to put down the time. So wait, excuse me. And I'll talk for about 25 minutes, and Yasmin's going to give me a little signal. Okay. So hello to everybody here in front in the audience and including online. Hello to you. We're going to be talking and thinking today about the regulation of the digital economy and particularly the big tech firms, and particularly the big tech firms have become like symbolic about the control of corporate power in all of our nations. And a lot of the nations are trying to control big tech, and this seminar today is on the antitrust side, but there are attempts to control big tech on a number of other issues, also privacy, deception, many others. And the big question I want to pose to us is, how well are we doing? When I say we, all of us who are engaged in the operation, and it could be on the side of the antitrust agencies, it could also be on the side of defense, but of big tech, but just the question of how well are we doing as a legal system to try to get at the abuses while enjoying the benefits. And my proposition that I want you to think about is maybe not too well. I might end on a kind of downer note, but do not think that I am a pessimist. I am an optimist. I want us to think about how we could do the enterprise better. So let me start. And of course, this involves thinking about various countries because there's no international law and international enforcer for competition. And the countries most prominent or jurisdictions most prominent in this enterprise are European Union, United States, and I'm saying South Africa because being here, I see South Africa as being one of the prominent countries. I'll talk first about some of the problems, second about what is happening on the ground. And the cases, the antitrust cases, and then the ex-ante regulation that some countries are doing to control the abuses of big tech. I want to mention, of course, Africa and its place, and I want to end by putting this together just very briefly, but across a big canvas about what's happening in the economic system of the world, and including the dilemmas of increasing nationalization, increasing difficulties of trying to come together as if it's competition agencies of the world, trying to come together to have a voice that is as significant as these very big companies on the other side. This is a very big challenge. First, let me just start with thinking about power. The firms that we will be talking about are mostly the firms in the category that have been separated out as gatekeepers or the most prominent big firms in the technology, big tech space. And just to give you an idea of the dimension, this slide gives you some numbers which are actually, I think, mind-boggling. That if you look today, if you ask your search engine, we'll be getting to search engines, but if you ask your search engine, what are the biggest 6 or 7 companies in the world? It will give you the top 6 are all big tech firms. And they have market caps of, beginning with NVIDIA, which is the largest, for big tech firms, because they were young and developing, they weren't on the list. Big oil was on the list. And Saudi Aramco is the number 7 firm now. I mean, all of the big tech firms are bigger than even Saudi Aramco. And all of the top 7, except Saudi Aramco, are big tech. So I put a couple of other numbers and thoughts on the board about how big these firms are in their own market space. The biggest is Google in its market space, and that is Google as a search engine, has about 95% and more of all of the search business in most jurisdictions today. And United States just slightly less. South Africa's less than, it's about 92%. South Africa's even more than 93%. So here's another way to view the bigness of big tech. It has across its head GAFA, which is Google, Apple, Facebook, now Meta, and Amazon. And the picture on the screen, which is a popular photo picture, is the problem of the big tech companies reaching into our legislatures, our executives, reaching their applying their power to have influence over these various institutions of government, as well as people, exploiting people and making loads of money. I don't want to forget that they're also doing great things for us that we like and that we want to do. And the competition agencies are not trying to prevent them from doing that. In fact, they're trying to preserve their ability to do that. So there is the ugly side. There's also an perhaps beautiful side. I don't want to forget that. But of course, when we as competition people, we're looking at it, we're looking at where are the abuses and how we can cure the abuses. This slide is simply a whole bunch of particular problems that we see in the competition field and that many of the jurisdictions are trying to do something about. For example, the gatekeeper companies hold their platforms open to companies that are often rivals of the gatekeeper and often squeezing out the rivals. And sometimes when the rivals are getting best, that's when they squeeze them the most. And very often the problems are that these big firms are creating barriers purposely so that it is hard to switch away from them to rivals, meaning that they preserve their position of power, and also making it difficult to port your data to another rival, which again makes it difficult for competition to come in. A lot of this has been attacked. A lot of the firms have given something, and that is they have reformed some ways, but there are still many ways that we see in which they are exploiting and excluding. The characteristics of the market make it more likely for them to do so. That is, to give us good things, but to abuse while they're doing it, getting power, and keeping competitors out. And those characteristics very dominantly include network effects. Because of network effects and these two-sided platforms, and the network effects, for example, that you all want, if it is Facebook, you want your friends on the same page. The more people on the same page, the happier you are. So this tends towards larger size because size does have an advantage for you. And it has a great advantage for the advertisers who advertise in the space that you see when you click. They make huge amounts of money by putting ads in the spaces that they know from getting all your data that you're interested in, you want to buy. So at the end of the slide, I put a line on fake online news and scraping, and fake online news is a big problem, but not particularly usually an antitrust problem. So I wanted to tell you a little bit about what's happening in the US on the US cases. Then I think I wanted to tell you, this is still US, I think I want to tell you a little of what's happening in the EU and UK. And then some on Africa. So for the US, I would begin by saying these cases come up on a law that in the profession we consider unilateral conduct law. It means a single firm. In US, it's called monopoly law. So you have one single firm that's very, very dominant in the market. You might have a few others that are struggling to be good competitors. And this is called, the act is called the Sherman Act, and it's Section 2 of the Sherman Act. It says no one shall monopolize. And so when you get into court with one of these cases, the plaintiff, which might be our federal agencies, have to prove the firm has monopoly power, which is more than what most countries have, which is dominant power. And then that what they do is anti-competitive. US has one of the most conservative laws in the world thinking about these problems in the following sense. And it's neoliberal in the following sense. We have, I mean, this is triggered, the symbol, if you're into this law, it is a case called Trinco, which was decided by a justice called Scalia. And the point of view is that markets work very well. And this is just another hitch when you get into international, because US markets do work better than most markets. When by work well, I mean people compete and the best one wins, and the firms have a strong incentive to give people what they want. And if that keeps happening, it's a process. It's what learned, I mean, it's what Adam Smith called the invisible hand. If that would happen, the market would work by itself. And the problem is that it doesn't work well when one firm gets too much power. And that's where antitrust comes in, to try to limit the power and make the market work. And if it works really well, it works for everybody, including poorer populations. So it's not just an elite game. But when firms get a lot of power, it often becomes an elite game, and that's a problem. So this case, what I say symbolically, think of a case called Trinco. It basically says markets work well when a single firm, not in a conspiracy with competitors, does any act. It has a strong incentive to supply people with what they want, and the market will catch them if they start doing bad things, exploiting people and excluding firms. So it's this presumption: rely on the market. Don't rely on government coming in. Government coming in, this is a perspective, usually makes matters worse. It's very inefficient, doesn't have the right information to make the right decisions, and it degrades market competition and the outputs. And also, along with this, a very, very strong principle of firms have, even monopoly firms, have a right to deal or not, and a right to deal on the terms they want, with a little box of exception, which would be where you get your antitrust case. So what I want to tell you is that even with these very strong burdens on the plaintiffs, there have been some big successes in the United States. Our Department of Justice has, under which we have something called Antitrust Division, has brought cases. Two of them, there's more than two of them, but two big ones pending against Google. Department of Justice has brought the cases. Most of the states of the United States have joined. There are too many cases to go into detail. There's Federal Trade Commission brought cases against Facebook, Meta, and Federal Trade Commission brought cases against Amazon. So let me just, in the shorter time, concentrate on one case, because I also want to tell you what just happened 2 days ago in United States against Google. So as I said before, Google is the one of these companies that's easiest to prove it is in a monopoly position. That's the first screen. But it's never easy. I mean, the plaintiff still has a really hard burden to show it has real power. Google always defends in every single case that it does not have power. The competition is a click away, that's in quotes, and really arguing strongly right now that AI is coming in and will make the markets competitive. So in this case, United States against Google search, this was the conduct that was alleged to be and then found to be illegal. Google had, I guess right now, has until it complies with the judgment, contracts with all of the sellers of devices like the Apple iPhone, and with others which are telephone companies who sometimes sell phones, and that's SELL, sometimes sell the devices that are phones, and can load on the device Google search or anybody else search. They have the real estate to load a search engine on that phone. And Google, I'll just say, one of these contracts, because it has a lot of the contracts with big players, is with Apple. It's been paying Apple more than $20 billion a year to have the right to have its search engine preloaded on the devices like Apple. And in many cases, to be the exclusive preloaded search engine. What does that mean, though? Does that mean it locks itself in? No, because it's a default. You can still, if you want to, and you want to go to the trouble, you can download DuckDuckGo or Edge. Might be a couple others trying to get into the market. I'm not sure, but people don't do it. And the court found this because that was a question, because Google said, I don't have any market power. And these contracts that you're attacking don't even have any effect, because all people have to do is load up another search engine. And the court, with testimony and evidence, found that just people stick to what was preloaded to a very large extent. A lot of people don't, but to a very large extent, they do. And as a result of that, these contracts where Google's getting the right to be the default search engine, Google is closing off the most efficient channel for the smaller firms to get a foothold and greater participation in the market. That turns out to be the way to get into and bigger into the market, to get the right to be preloaded. And so these contracts were held illegal almost a year ago. And 2 days ago, the judge came down with the relief, the remedy. So the remedy, it's a very long opinion. The judge, before I back up a little to say this, the Department of Justice said that the problem cannot be remedied without a breakup of Google. And spinning off Chrome, which is the search engine. Chrome is the browser that carries the search engine. Sorry. Spinning off Chrome was the big effort that the big project that the Department of Justice asked for. And incidentally and interestingly, the Biden Justice Department asked for it, and the Trump Justice Department also asked for it very specifically and affirmatively. So they were in line. The judge refused the breakup. The Department of Justice said, without a breakup, things are going to be just as they always are. If you simply prevent the contract of buying the exclusive default, because Google has been doing this for more than a decade, and it has gotten bigger as a result of both being better and doing this over the last decade. Google has a kind of locked-in position, very hard to open up. And the Department of Justice was saying that nothing would happen unless you have a breakup. And the court said, no breakup. It was pretty predictable it would say that. Jurisdictions don't usually break up a firm. A usual problem is if you break up a firm, it doesn't have to be the case, but a usual problem is that you are disrupting the business that the firm does. And part of the disruption is bad if it is disruption can be very good, but part of this disruption can be bad if it prevents Google from getting us the service that we want. So the judge didn't grant the breakup. The judge, of course, said that the illegal contracts had to be stopped. And it also said, which is very interesting, that Google has to give some data to qualified entrants, new entrants, and little firms to be able to be on a somewhat more equal plane. It's not very equal, but somewhat more to get a better foothold into the market. The judge did not enjoin Google from paying whatever it wants, billions if it wants, to get the right to be preloaded on the devices. It can still pay. This was a huge question, whether it should not be allowed to pay. So it can still pay. It just can't be the exclusive default, but it can be loaded as one default on the phones, and it can pay for it. So whether it would be allowed to continue to pay was a really big question. Apple and other companies that were receiving all these billions of dollars said, Judge, please keep letting them pay, because if you don't let them pay for this right, it's really going to devastate me. And also, Apple and these other companies were saying, we really wanted Google as a default to make it easier for people who use our device, because they usually want Google and it makes it easier for them to use it. So they had many of these arguments that also went to the liability. They didn't win. My prediction is that things will remain the same, that the relief probably will not open the market, that still the little firms will not be able to contest Google, even though Google did something that was illegal. And it's just an example of these cases they're hard to win in the first instance. The remedy phase can make it virtually a Pyrrhic victory. Now, I probably am using most of my time already.
No, we're here to listen to you, Eleanor.
So the judge said in giving...
Oh, you're fine. You're fine.
Okay, just one more on this point. The judge said in deciding what relief to give, AI is here. It's getting very important. Google says it's going to really revolutionize and shake up the market. And AI might become the big alternative to Google. And I'm going to count on AI to do the work rather than a breakup to do the work. And I have to tell you, I just told this to a reporter because I'm not sure how many people realize this. In the opinion on liability, Google raised that same argument. And the judge said, well, AI, this is very speculative. We don't know how it's going to roll out, and we can't count on it anytime in the near future. I'm not so sure that so much has happened over this last year that changed that, but the judge liked that argument because wanted to have wanted to be able to say and hopefully have the market working rather than the regulatory relief. The EU has been pretty successful in the cases that it has brought against the big tech firms. At the end of those cases, it has fined Google and others also. For Google, about 8 billion euros. And the company and Google has paid it, but you know, it's not a big deal for Google to pay $8 billion. And this is a problem on getting deterrence. If you have a conduct that gives you back a huge amount of money and you have a fine to pay and you can do it and you get more money by violating the law becomes not a good deterrent. This is a problem. The EU recognized that these cases, the EU cases, have taken many years, about 10, to go up to the highest court. By the time you go up to the highest court, the conduct has worked. It's ill. I mean, this is a really big problem. The markets are changing fast enough so that you see conduct, you think it's abusive. If you cannot stop it, if it is abusive, if it really is anti-competitive, still, you cannot stop the conduct in a time that makes sense to help the market work better. So if Google were not doing this, closing this door for entry and success of smaller firms over the last more than a decade, if the conduct had been caught on day one rather than decades later, you would see a different market. And this is a really big problem. So EU notices the problem and says we need a different kind of regulation. We need, and as well, not to substitute, but to add, oh, I know, I'm at the end of my time.
No.
It adopted what you call ex ante regulation. It said there has to be a better way. Every court, every time Google goes into court, it says, I don't have market power. The competition is a click away. The judge's opinion of 2 days ago is going to give it more strength in making the argument, because you're always looking at the future. If I have it today, I'm gonna lose it tomorrow because of AI. And so this costs money to litigate. So every time it goes in the court, you litigate, does this firm have market power? You litigate, what is the effect of this practice you're challenging? So EU says we ought to be able to develop a list of what is harmful, just practices that we can describe in not too many words. And we ought to be able to develop a category of the firms that are doing this negative stuff or likely to do or can do, the gatekeepers. So they enacted this system, which is called Digital Markets Act, and a category of gatekeepers. They have to do some work to find out if the firm qualifies as a gatekeeper, and these listed on the board do qualify in the European Commission's competition unit point of view. And then the idea is, if the firms can comply with the list of do's and don'ts, and the agency doesn't have to prove the bad effect each time, doesn't have to prove the power, and it doesn't have to prove the effect, that ought to be a system that works much better. So they're trying it. It's a system that has its own problems. There are contests of whether they're a gatekeeper. There are contests of whether they come within the list of things that they can and cannot do. It is in progress. So this is just a list of some of the do's and don'ts of the ex-ante regulation. A number of jurisdictions around the world like this idea. They agree with the basic principles of the idea, and they're trying to implement it themselves. The UK has a system similar that's on board. Africa, this slide is about the African protocol, simply to show you this is the protocol for all Africa in the Africa Free Trade Agreement. And it's very interesting that in that protocol itself, it has more detail about controlling the gatekeepers in big tech than almost any other competition statute. And you can see this is a list of do's and don'ts right in the protocol. It needs a little more ratification and then appointment of a chief and appointment of the staffs and everything before it can go into effect. From the point of view of most of the African countries, the ability to control the power, when I say that, I mean used in anti-competitive or exclusionary ways, is very important. There are so many small and middle-sized businesses that actually have a great prospect of doing something important and making a firm that means something if they can only get online and be online. So if they could get onto the platforms, it could be of Google and the other companies that offer the platforms. And very often there's some gap between what they're able to do and the platform, that they can't quite reach the platform, and they want the platforms like Google to do something for them to try to close the gap, just lend a helping hand when the helping hand doesn't cost too much to Google and it's absolutely necessary for the business and viability of the small business. So that's one of the aspects that the African countries are working on. And now you're going to see the tone shifts here a little bit. There is pushback. There is huge pushback by countries like mine, and especially now when my president is saying, just before we think of South Africa, I'll come to this in a second, when my president is saying to EU right now, I think you enacted the DMA to get our firms, to put burdens on our firms. Well, of course, when you see the list of who are the big gatekeepers, they're all from the United States. So Trump and his enforcers all over are saying, you're targeting us. This is unfair. We don't like it. And he is saying right now, and negotiating with the head of the EU right now, saying, if you don't give us an exemption from the DMA, that's Digital Market Act responsibility, I'm going to put higher tariffs on you. So this pushback as to South Africa it's just a sample, but it is the kind of thing that you are seeing from, I think, mostly from neoliberal community and community that supports Trump and MAGA. And South Africa, as you know, came out with a media and digital inquiry report a few weeks ago. And the firm that is saying these things, I'm about to read a line or two, is called Information Technology and Innovation Foundation. Quote, South Africa's weaponization of competition law. That is, it's accusing South Africa of weaponizing its competition law to be trying to get some duties enforced of dominant firms that are doing business in South Africa. So South Africa's weaponization of competition law forces U.S. technology companies to divert substantial resources from innovation to compliance with market-specific demands that fracture global platform consistency. There's a lot more and a few more on this page. The commission, that South Africa Competition Commission, approach establishes dangerous precedents for politically motivated platform interventions globally. The South African authorities compromise the proprietary technologies and operational efficiencies that underpin American digital leadership and deter investment in emerging markets. So this is what we have to contend with. When populations that need to control abuses that hurt them are working to do that, they're going to be pushed back more than ever in this economy and geopolitics where nations are more and more nationalistic, mine maybe first among them, doing what they think is good for themselves, which might not even be good for themselves. So on the one hand, if we were in the world of 10, 15 years ago, it would be a totally different tone and a different story. The world, the agencies of competition were working together to try to make a better world, more coherent world, a world in which you give and you take and you have respect, and you build on the synergies of one another. We're not in that world anymore. If we were in that world, we would be looking towards more common agendas, more norms that were compatible, more ways of saying, for example, there are certain things that are anti-competitive. If you want to put it in big tech terms, big tech, there are these abuses that are anti-competitive. These are norms of the world. You, the big tech companies, just should not do them. And we all agree. I mean, that's my notional vision of the collaboration and cooperation that results in common norms. We're farther from that today. I'm often told that's naive. Well, it's more naive today. So in conclusion, I quote, things fall apart. You know that the center cannot hold. Mere anarchy is loosened upon the world. The best lack conviction, while the worst are full of passion and intensity. Thank you.
Thank you, Eleanor. That was very thought-provoking. We're not depressed because we come from South Africa and we know how to fight.
Oh, good. Okay, that's what I want to hear.
So, well, you know, it is concerning because how do we regulate big tech power? Do we do ex ante? Do we do it case by case, which would take 10, 15 years? Or in South Africa, do we do it through market inquiries? So just to give you a sense of how we're going to run this session, I'm going to ask my panel members for a few comments if they have any. No, you're not compelled. And then I'm going to open the floor to questions and just to make it a little bit more interactive and for people to enjoy the time with Eleanor. And she doesn't have to answer all the questions. That's why we have this eminent panel here. And I think we might enjoy our session a little bit more. So Derek, let me start with you. And you want to jump in here, maybe?
I'll be very quick, thank you. But what I found quite humorous, if I don't need that, when on that Google decision, was it was written by Judge Emerita. so when I saw that, I found it. But I did see it. I mean, I haven't read the decision or the opinion, but it's interesting how much weight was placed on the impact of Gen AI in changing the judge's decision, which I think is interesting. And I've worked with a number of people in this room. I better behave myself, especially on the media inquiry and some others. And just in the time of the media inquiry, how the nature of Gen AI and the submissions we made about it has changed. It's so dynamic, so ever changing. And so, but let me put on my glasses as well. But I hope to make some contribution. I think I'm here because I'm paying for the drinks, but hopefully I'm making. Thank you. That's very kind. But when I got Professor Fox's slides, I was reminded of a conversation. Many of you know my father as a school teacher and educator in KwaZulu-Natal. He asked me one day what I did for a living as a competition lawyer. So I think many of you will attest, describing what we do can be somewhat of a challenge. But what after a bit of back and forth, he said to me is, it sounds like what you do is you worry about the Lord Acton saying, you worry about power corrupting absolutely, even in the hands of good people. And I mean, it doesn't capture what Professor Fox has said, but I think it does to some degree, because it's something that antitrust since the Sherman Act has been grappling with. How do we appropriately deal with the accumulation of societal power, economic power? How do we proactively inhibit that where appropriate, without inhibiting market-based outcomes and also innovation? And this is the debate that's been there from the outset. It's about power. I mean, Tim Wu's book recently talks more about the structure of things, but that is really what it's always been about. In the past, it was about oil and railroads. Now it's about complex markets and within the digital space where new technologies are fundamentally changing the way in which we do things and requiring of us to adapt. I also noticed your comments around the political realm, and the debate is now becoming fairly ideological. It's becoming subject of lobbying. It's moving into the political. It's within the political power realm, within its impacts national imperatives, and in the political realm. And Eleanor mentioned this threat just a week ago. And I think the one I read about was with respect to the DSA, not the DMA, where the threat was that EU officials would be sanctioned if they enforced the Digital Services Act in the EU and in member states. And things have also changed. I mean, you now see XAI bringing a claim against OpenAI as well as Apple. So it really is quite a dynamic environment. But that sanctions is quite uncomfortable, I must say. Trade tariffs is one thing, but sanctions is another. Yeah. Then, I mean, you can just imagine within this environment what challenges regulators will face in trying to regulate these markets. And this is where these markets are often global in nature, and where firms have international terms of use or models that apply throughout the world, yet where their impact is local or regional. That's in fact the central question which the Commission has been dealing with in the retail market inquiry, as well as in the media inquiry, as well as to some extent what's before the tribunal in the GovChat matter. And the challenges for regulators is worse because of the uncertainty that and where, and for example, the impact of Gen AI, where I'm seeing the debate percolating into two areas, where on one side you're seeing Gen AI having the argument being that it's going to transform human capability and even reduce inequality, whereas on the other side, there's stark warnings about the consequences for humanity and societal power. Now, this is where I'm going to be a little bit contrary, so I'll just forewarn you. While I recognize those challenges, I hope you don't mind me being a little bit contrary, but to suggest that there's still a debate to be had about what the appropriate assessment should be for assessing competition harm within the digital space. There's still room, I think, for debate around where the prevailing ex ante or presumptive approach that's gaining prominence around the world is right in all instances, and whether it's undermining a economic effects assessment, especially in matters that are clearly vertical in nature. So I'm going to ask some questions, and I'm not saying these are my positions. I'm just going to ask some questions, and maybe they'll be part of the debate. But that will be to ask the question: is the prevailing narrative that digital markets are inherently anti-competitive and require special regulation right in all instances, when in many cases they don't actually display the typical features of monopoly power? There's not lack of growth, there's no underinvestment. A question: should all of these firms be lumped together? Google, Apple is different from Google in many respects. So too from Facebook. So too from cloud providers. Not always conducive to the network effects that are feared for. There's been is there a debate to be had about the mixed bag of outcomes for the US regulators in particular? For example, the FTC was unsuccessful with respect to block Meta's acquisition of Within Unlimited, and so to Microsoft's acquisition of Activision. Is it right to attempt to recast vertical integration in the same light as horizontal mergers, when mostly vertical integration is seen as benign, and if not beneficial? Another question is it right to be de-emphasizing consumer welfare in favor of the structural features of markets, and potentially unduly shifting competition law away from robust economic analysis? And finally, is this inhibiting innovation and the introduction of new services? You just saw a while ago Apple and Meta withholding certain features in the EU because of fears about the DMA. Google withholding certain features on the search page because of their concerns about what the implications of that could be for the DMA. In the DMA, I asked these questions at a recent AFTA event, heads of competition authorities, which I had the privilege of attending, with specific reference to Article 11 of the competition protocol. And I was happy to say that the consensus is that these issues are worth debating, because the central question is, what is the test that should be applied to assessing where the conduct of the digital space is anti-competitive? There's, I suppose then the question is, what is there for regulators to do? And I suppose what I'm suggesting is that, to the degree that regulators consider it appropriate to adopt presumptive approaches in their assessments, they have to leave room for respondents, participants in the market to justify their conduct, explain their conduct, in particular by reference to the consumer welfare enhancing aspects of their products. In my experience, one thing I think that is right and should be done and should be emulated is market inquiries. I think the way to go is probably market inquiries. That gives a regulator enough time and scope to assess markets. And maybe the answer is to use onuses, legal onuses, in a proper way. So, and I suppose regulators sit with an information disadvantage. They don't have all the insights. But if they are able to present a particular case then maybe an answer to this debate is to deal with it by reference to legal onus. But importantly, to be able to allow respondents to justify their conduct and explain that their conduct isn't necessarily the subject of market power and is actually good, doesn't have the outcomes that people are fearful of. In my experience, what my clients want is to just know that when they're before a regulator, they're going to be treated fairly, they're going to be subject to independent assessment, and their evidence will be heard. And I think market inquiries and the Commission's track record is there. They're doing as good a job as I think they can do. But the responsibility on the regulator in an inquiry is just that much more. And they need to be seen to be weighing things appropriately.
Thanks, Derek. Just to say that Derek's talking about the context of antitrust legislation. And I know there are people here not all from competition law background. Just because he says we should be not regulating big tech under competition laws doesn't mean they shouldn't be regulated under other laws, like data protection or any other consumer laws, because it's important to understand that market power is not only from the technology of network effects, but also from the data itself. So I don't know if, Imran, you had any comment at this stage about, yeah, go for it.
I wanted to make some remarks about this AI question and whether this is going to be the savior and is going to change this these markets. And I want to make three points really. If you're as grey as I am, and I can't see anyone else who's as grey as I am. Yes, Eleanor. So, kind of Eleanor and I will remember a world before before. We'll and remember a world before the internet. And when the internet first emerged, there was lots of thought and lots of writing that portrayed the internet as something that was going to be truly emancipatory. It was going to give us freedoms that we hadn't really imagined. I think if we reflect on that now, I think it's fair to say that it has generated things that we hadn't imagined, but it's also generated a kind of a real concern about abuse of economic power. So when I think about the AI thing, and we're kind of investing a lot at Wits in kind of in this, I think it does have that sort of emancipatory potential. And I think the challenge we face is how do we think these markets might evolve, and what do we need to do to learn the lessons from the internet? So so that's the first point. Point two is if you really look at what's happening, it does appear that these markets are highly competitive, and if you think about what kind of DeepSeek did to the valuations of these companies, there is some sense that that these markets might be evolving in a way that is quite competitive. But I think the concern for me is that we sort of talking here about companies and kind of institutions that have deep pockets. So kind of in 1 year, I read that Google's investing $75 billion in kind of in AI development. Kind of how is a small player or someone kind of in Africa supposed to compete with that? the last point I want to make is that we really need to think about AI and what it can do for us. And I think it has the potential to solve many problems in Africa, but it's going to require us to have some role in that space. There's a fantastic piece that my colleague who kind of heads up our kind of AI Institute, Benji Rossman, published in the Daily Maverick 2 days ago about the need for some sort of AI sovereignty in countries such as ours. And he makes the point there that if we can't be in these markets, then all of our resources and all of our data is being used to solve someone else's problem. So if you think about health markets, we want solutions for our health problems, and we want our AI to solve our health problems. If we don't have that capacity, it's not going to do it. And I think for me, the concern is we kind of moving into a world where large amounts of economic power is now going to be working in tandem with quite abusive power in the politics space. And I think that sort of raises some really important questions for us.
Thank you, Imran. I mean, that's very important to bear in mind what Eleanor was saying, the benefits of the technology versus the abuse of the power, the economic power. I mean, it's ironic that while we are here, there are other people online watching the seminar, and let's not forget that we can reach people long distance, which we've never been able to do before the age of internet, except with a horse and a car. John, you know, something to say?
A little bit. But the first thing to say is, I remember even before there was the internet, I remember before there was email, which was more or less. So yeah, just a couple of points. One is that, well, the first thing is just, it's great to see, I think actually there is a competition law class here, even though we're not running one this semester. So it's great to see actually a number of students that are here. Not only actually, I must say, students in the competition law class, but also the teachers. There's a lot of people here who actually in the competition law community have been part of doing the teaching and really the instruction there. And I think actually one of those people is Professor Fox. So I'm really pleased that we're in this. So 3 substantive points, and I think maybe they work particularly well with some of what Imran said. But I want to focus a little bit more on the politics part of it than the markets part. Although I think it's very interesting, and the first point is to see the degree to which those two are almost overlapping. So we're seeing more kind of business and market-like behavior in politics, and also a certain amount of politics and power, more than a certain amount, in the markets. So Tracy Lynn, you were starting us out with disruption, which has kept going as a bit of a theme. So, you know, in competition law, when we like disruption, we say it's a maverick. But when we don't like disruption, we call it other things. So I just think it's worth thinking about. It underlies, I think, your presentation and some of our comments, but the degree to which, Prof Fox, you were here last year. We hope you'll be here next year. But since you were here last year, a lot has changed. And not just in the AI space. And so, and that's, I think, a certain twinning or certain sort of morphing of politics and markets. So the second point is going to the real political substance of that. So we have a real American law professor here who I think is going to be, well, I want to invite her to make some comments or give us some clarity effectively on what's going on in the, but particularly in the antitrust world. And it's even interesting, Prof. Fox, from what you were saying there about, for instance, in that US versus Google case, very interesting, right? The jurisdiction against Google, where we often think of those two together. You were pointing out how the Trump DOJ was actually continuing to press for the remedy that eventually the judge did not order. The DOJ, there's also the Fair Trade Commission, the FTC there. I think it's really, there was a lot of speculation, but not a lot of clarity in the beginning of Trump 2.0 as to exactly what kind of stance was being taken by the US administration, pointing to Imran's point here about the potential twinning of tech, of the business power and the political power. So maybe if you can help us understand a bit about that politics and the transparency. The last point is on the South Africa geopolitics. So still in the politics world, we feel like the politics has changed, and I'm going to be, I think we all are in some fundamental ways, staying with the notion that we can find a way forward, that there is an optimistic thing, an optimistic way forward here. So Eleanor, you've really been one of, certainly there is a absolutely vibrant and distinctive and in that sense, indigenous competition law and policy school and community here. Yet, particularly maybe in articulating how Africa might have a voice in a global economic community, you've written several pieces with that theme and pulling on, well, recently at least with the AFCFTA. So yeah, where do you see that going in this disruptive world? Is it a place where the voice of Africa becomes, you know, kind of squeezed out, or does it find its, you know, are there fissures, are there disrupted places where that voice can actually, I don't want to say is AI amplified, but let's just say is heard.
Thanks, John. Got a lot to think about. Eleanor, I don't know whether you want to respond to John's question now, and then I'll want to open the floor to other questions which can be dealt with by the panel.
Yes, yes, I would like to, and thank you all for your really very interesting questions and insights. So I'll respond to John's two questions. The first one being what is the lay of the land on politics under Trump 2 as related to competition policy? And to answer that, and you've already projected this, and I did too, something very interesting happened with respect to our Republican Party. This relates to the DOJ supporting the breakup relief in Google. The Republican Party in the United States and the Democratic Party are the two significant parties. It's really a two-party system. And the Republican Party, until recently, has traditionally been conservative, and you would put your neoliberals into that party, and they would be very pro-business. And you would expect them to be anti-breakup as really remedy in a big antitrust case. So the interesting thing that has happened is there's a big segment of the current Republican Party that are MAGA, that is Trump's segment, Make America Great Again, including Vice President Vance. I don't mention Trump because Trump actually has a lot of ad hoc loyalty. I want to bargain. instincts and not necessarily much ideology that fits with what's good for antitrust policy. So J.D. Vance and many others are of the view that there is huge corporate power that is negative, that's been overtaking us, and we ought to deal with it. Along with the Democratic Party being of that point of view. And often their viewpoint will be expressed in view of big tech. And often when it is expressed regarding big tech, the line is that big tech has been suppressing conservative views, that this is the principal power point. They're very unhappy with the liberal thinking ideology, and they think most of big tech, most of the time, are deplatforming X, or not advertising on X. I'm saying X, that is Elon Musk's vehicle and its very conservative views. So much of the rhetoric is against big business because they think big business is anti-conservative. So this leads me into saying, how does that play out on what's happening right now in competition law? And one other thing I have to say as background is, in Trump 1, the Antitrust Division brought the suit against Google. So even in Trump, even as far back as Trump 1, which is beginning 2016, Trump and colleagues, inner circle colleagues, were already of this view that became much more well-formed against big tech because of thinking they suppress conservative views. So now we go to today, what's happening in antitrust and the Trump administration. And also, meanwhile, during the election, this last election of Trump, the big tech companies got a little scared of being on the wrong side of Trump and gave him millions of dollars in the campaign. Clouding the water. I mean, this only messes up things. It doesn't make for clarity, because Trump and administration are wanting to get big tech, but on the other hand, Trump loves people that contribute big amounts of money to his campaign and usually wants to do favors for them. So we were wondering how it would play out, in whether the Trump administration would keep the view of the Biden administration that the remedy, the most important remedy, in this case, Google search, would be a breakup. And they did. They came out forcefully for it. We're still waiting to see what's going to happen on big tech, because Trump changes his mind sometimes, and there might come the day when he wants to award the loyalists, and so we don't know where and that will play out. But there's one other layer that I want to tell you about as what is happening in antitrust today that is in US that's very alarming. The Trump Justice Department is putting ideological values into the cases. For example, there will be a merger case where we don't think there really was an antitrust problem, and Trump settles it. One is allowing Paramount to make an acquisition. Paramount owned CBS. CBS said some things negative to Trump during his election, and Trump sued for defamation action against CBS. And Trump, through the Justice Department, antitrust, said, okay, Paramount, you can have your merger if you promise to give me some millions of dollars to settle the case that you were due to pay me. And a similar type action is happening. It just means that antitrust is much less pure than it used to be. And conditions are put on mergers that don't have anything to do with antitrust, that can be vindictive and they can be ideological. So the other thing, I interrupt my own sentence, that another example is there's a big merger, Hewlett Packard wants to acquire Juniper, and that goes through services to local networks, such as to colleges and other institutions. And the Justice Department Antitrust Division, under the new enforcers, thought this was a problem and a big problem. And it looked like they were on the track maybe to try to enjoin the merger, maybe to get a settlement, but to get a very strong settlement. And the Trump administration went over the head of the Assistant Attorney General of Antitrust, whose name is Gail Slater. And the law firms hired lobbyists who were very good friends of Trump, and they settled the case on very light terms. And this is a scandal right now in the United States. And it came out because that one of the chief deputies under Gail Slater, named Roger Alford, did not want to sign on to this deal. I do believe Gail Slater did not want to sign on to the deal, but that has not come out. And when Roger Alford expressed, I won't sign on to it, it's a bad deal, it's not an antitrust deal, it's just a cronyist deal, he got fired. And he was able to tell this story publicly, but he is now under the pressure of being accused of having told private information in public against the morals and ethics of a lawyer. That's the end of that part of it. You probably don't want a long part, but you did ask me about, was it the voice of Africa? I wanted to say something about the second. So what does all this negative geopolitics mean for Voice of Africa? I think, and when I have been saying Voice of Africa, I did put that, as Jonathan said, I put it in connection with there being an African protocol. I think it's about to be finished being ratified, and probably within the next year, it might be online. Operational. And then there will be a head of antitrust for Africa. And I have been saying, there are many transactions, and many of these will be world, not just Pan-African, where it's very good to have a head of African competition, but it might be big world mergers. And the mega mergers in the world have all been going through. They've all been, the big jurisdictions look at them and they say, what do I need to protect my citizens? And I'll do this and spin off that. And US does it, EU does it, hands over the problem to the rest of the world. The world that's the part of the world harmed most is the vulnerable part, which is developing countries. And they do not have the wherewithal, certainly, to enjoin the merger, and otherwise really to protect themselves. So my thought is, once there is a head of African competition who could sit at the table on day one when a mega merger comes through, and it's very harmful to Africa, and the correct right relief for Africa is to enjoin it, that is a good voice for Africa. That will still, if that all happens and you do get a person at the head of African competition who is strong, has a strong message, is able to put together the view of Africa, I think this is a real possibility, and that possibility is not diminished by the geopolitics. That is geopolitics today, or is not undercutting that. I think that in many of these mega merger cases, it's the US and the EU are forced to look at what's happening in the whole world, and they realize that they too are hurt by the same merger. They might be convinced that an injunction is really fine, an injunction that they could do nationally in their own jurisdictions. Like US could say, I enjoyed the merger. They'd be more convinced that they're not stepping on other countries' toes by doing a relief that goes beyond their borders. They'd be more happy that the world is in line, the world of enforcement is in line with doing this, so they won't be concerned about impermissible extraterritoriality. So yes, we proceed down the line of getting a voice for Africa.
Thank you, Eleanor. That's very optimistic of you.
I know, but I told you I'm an optimist.
No, that's good to hear. On this note, I think I'll open the floor to questions, and Jonathan has agreed to assist me, and I can see. Oh yeah, no, Tracy, do it.
Thank you.
Eunice. I see Vicky, and next to you, 1, 2, 3, 4. We'll take we'll take 5 now in this round. For me, 5, and then I'll note 2 for the next round.
Hi, my name is Mbegezeli Benjamin. I come from Judges Matter at the University of Cape Town. I wanted to ask Prof Fox, thank you for that presentation. The golden thread that I see, I'm not in competition law, by the way, but I'm interested because I have a lot of competition law friends. And I'm interested in what you mentioned in your presentation, which is that the regulators are asserting their authority against big tech, which wields a lot of power as corporations, but also this power is manifesting as sort of political power. And I love that you mentioned the remarks that the Trump administration is making against the EU, that they want to sanction certain of their regulators for regulating the way that they should, tech companies. Well, in Brazil, they are talking a very different story in that it's not just tariff issues. The US State Department on the 31st of July sanctioned a Brazilian judge of the Supreme Court for something that is absolutely has nothing to do with the United States. The Supreme Court of Brazil is prosecuting the former president of Brazil, and it has only to do with Brazil, and the US State Department sanctioned the judge. So my question is, what advice or what kind of guidance would you give to African regulators who want to regulate for the interest of their own populations, understanding their context and understanding that, yes, they're using competition law and maybe other laws to regulate these big tech companies, but how do they do so in the face of the corporations using their lobbyists and other people in the White House to sort of do their bidding? You mentioned earlier that MAGA was very skeptical of big tech. I don't think that is the case anymore. Tim Cook has been to the Trump White House more times than he's ever been in history.
I wanted to ask if there are any moves to try and deal with the gig economy, because I think that's a massive thing. And in South Africa, for example, there's just been an Uber strike. But it strikes me that these platforms who were very clever and spent a lot of money on marketing and did a brilliant job are now becoming extremely oppressive. And that's a labor issue, but I don't see these strikes working. So I just wonder if there's any remedy, maybe not one in this room, but any remedy that one can think of to try and address these sort of issues of being stuck in this sort of gig economy.
Thank you. My name is Loreti. I had a two-part question. The first one is just very brief because of the case law you spoke about with Google. I just wanted to know, what did they say, because I haven't read it, about companies approaching Google themselves, contracting and saying, I want you to be the default search function? What limitations can the government or legislation put on another company wanting to use Google or Chrome exclusively? Did the judgment speak on that at all? And then two, in South Africa, I just wanted to bring it back a bit locally. If you look, she said about Uber Eats, but I was also thinking of Take-A-Lot and Mr. Delivery, and they basically are a monopoly, but they're not considered a monopoly. So I was wondering, what have the regulators in South Africa said about that? I mean, a lot of people talking about Checkers 360 coming up, but they could be seen as the disruptors. But what's been done? What is being done about Take-A-Lot or actually local monopolies in the tech industry as well? Thanks.
Thank you. Hi, everyone. My name is Mpumi. I'm from the Competition Commission. I have a very competition nerd question, which is the Competition Appeal Court in the Vodacom case was very critical of the Competition Tribunal for engaging in what it's called the dynamic counterfactual. So its horizontal theories of harm were dynamic in nature and not static, in that they viewed the potential of harm to the market, not only on today's terms, but thinking about how the market could change in future and regulating for that. It sounds like with this remedy that you're talking about, there's almost a similar dynamic assessment happening, because the remedy, it was seen, I'm talking about the Chrome divestiture remedy, was seen as mitigated by the potential for AI technologies to come into the space. That also seems like a dynamic, and it can't be called counterfactual. I don't know what it's called in the remedies context. When you have an abuse, but you're thinking about a remedy, and you're thinking about a remedy from a dynamic prospective insight into the future. So my question to you, Eleanor, is one, did the judgment give us any tangible framework for the evaluation of fact in making such dynamic assessments about the future in an abuse case, which we don't really hear about? And then second, my question is to the tribunal panel members, past and present, if there's, if you have any thought on the South African potential for a similar exercise in digital markets, where we think about our remedies not from a static perspective, but from a dynamic perspective. Thank you.
Do you want to?
Okay,
Feel you
so-
want to pass it along to us?
So I'll start with
For me.
questions. And your last one. So you mentioned how to deal with dynamic and especially counterfactual. I would approach it by saying, first of all, it's totally proper to deal with expected dynamic changes, even though it's based, even if it's based on what you can call theory rather than hard facts, in the sense of the companies are positioned this way, what are their incentives, what are their profit motives, what are they probably going to do next because of how they're positioned and their profit motives, and that's totally fine. A big question is, how far in the future are you going to make assumptions? And the farther in the future your assumptions are on less solid ground. So in the Google search case which just came down on the remedy and taking a lot of decisions based on a prospect that the court does not know if it will happen or not, it's within the judge's remit to do that. And the judge could have put more emphasis on another prediction and possibility, saying what's going to happen given the relief that the judge did order, and at some point before it ordered, was thinking about ordering. Would the judge really predict that the market would open up? It's part of the same question, because he thinks the market will become competitive because of AI. He hopes the market will become competitive before AI. It might have been a stronger presumption that the market will stay the same. Given his relief, the market will stay the same. It will not open up. Whether AI will cause it to open up is a very prospective decision, making a lot of assumptions. So I would have thought treating the dynamic and giving the latitude to make the predictions, possibly the predictions were made the wrong way. And possibly, though, they were made in the direction they were made for a different reason from being tightly focused on your questions. The reason that judges don't want to break up companies, I mean, especially when they can't predict what will happen in the breakup, and they're very rightly worried that a breakup will cause the denigration of the product. They don't want to hurt us as consumers by degrading the product, and they're very worried that will happen. Breakup is a drastic remedy, and big disruptions can happen, and they could be good, but they might not be good. It's all a prediction. He's much likely to get overturned by the judgment he made. If he made a judgment for breakup, it's very, there's some good possibility he would have gotten overturned by the higher court.
I just want to step in and say, as a former tribunal member, I can speak to whether tribunal members would have a similar approach. Firstly, a merger of the nature of Vodacom Maziv always changes the market. We're not looking at a static market. The market is dynamic. It now has dynamic aspects to it. The counterfactual can never be static, right? Because it's a merger between an operator, telecoms provider, and inputs fiber. One dominant firm merging with another dominant firm, the market is totally different. And secondly, we've always considered dynamic counterfactuals, never been static. So, and there's history for it. We have divestiture in many other matters that in South Africa we've had that, but even in the US, you can go back to the old telephone days. It's a network industry, and you're looking at network effects, and you're looking at what will give a company an easier way to gain power or retain or maintain its power. So you might all remember the baby belt breakup of AT&T. That was a big breakup in the US. People forget it because, of course, you don't even know what that phone looks like. But there's precedent for why you would break up a company because authority thinks its power has become too big to be able to contain in a way that's not going to be abusive or exploitative. So, you know, on that score, I think the CAC might have forgotten that there is a lot of history and precedent for that. Having said that, you know, Eleanor is right. You don't reach for a breakup very easily because you have to also let companies do what they are best at doing. So on that score, maybe I should just quickly ask Derek to comment on the take a lot thing. I mean, you don't have to, it's been done. We don't have to answer every question.
It's and just one point. One thing I was not suggesting is that big tech should not be regulated.
Yeah, no.
I think it should be appropriately, but scope should be made for proper economic analysis. And just one other thing, the situation in South Africa, or the issues in South Africa are a lot more complex moving into the public interest beyond the narrow discussion about antitrust that I was focusing upon. But you're right, the Commission has intervened. They have looked at online retail, and they have made findings that require online retailers to conduct themselves in a particular way, ranging from parity provisions and the like. But it's also interesting, just in the time since the online inquiry, that market has changed. And I don't think it would be right to say necessarily that the likes of Take Lot or other clients have the market power that was assumed during that inquiry.
Yeah. Nan, do you want to address the gig economy? Biggest question about how do we, given your work on the commission and basic wage and understanding labor dynamics, how do you see her sort of, is there a solution? Is there a way to deal with it?
Look, I think in the end, these are kind of questions of power, right? They kind of questions of unequal distributions of power, and I think we need to think very carefully about how one tries to rebalance those power relationships. So to take the kind of example in South Africa, I think the national minimum wage does give a lot of power to people in kind of in the gig economy, in that it has set a floor for what would be kind of reasonable earnings kind of or not. But I think to come to link it to Mpumi's question, kind of anyone who tells you they can predict the future is either a fool or a liar. And I think that's the difficulty, right? So I think we have that. So let me try to deal with that one, not as a tribunal member, but as a university-based economist. I think the kind of innovations in data and kind of economic modeling allow us to make much better predictions of what these outcomes would be, and to go back to the minimum wage question. Before that law was applied in South Africa, we did a kind of huge amount of work on trying to get some confidence about how high could you push that wage without ending up in a world where you're going to kind of going to increase unemployment. And I think in many of these questions, you really have to think through some of these trade-offs. But I think our technical abilities to do those are kind of improving all of the time.
That's Eleanor, yes, I'm going to open for another round of. We'll have another round of questions. Tracy, there were two hands here, one and then one behind two there.
Thank you very much, Prof. Yeah, thank you very much, Prof, for your presentation. I'm not an expert in antitrust, so I will be a bit pedantic with my question. Based on some of the examples that you gave, I'm just a bit confused about what sometimes the objectives of the antitrust experts or the antitrust practitioners are interested in, way beyond whether there is any actual harm or they are just interested in this accelerating economic prowess or innovation capacities, or just the incentive of bigness within any market. For example, if I take the issue around Google and Apple monopolizing, as you put it, payment systems on their operating system. So this is a free market. I create a private property, an OS, and I say, I don't want anybody to get on my property. And then we see it as a big problem. Why, for example, in the layman's stance, people build very big houses, they're very homeless people, and we don't see too much fees about that. Why don't we open it up? The military-wise, for example, NATO from the EU, US, no African country can compete with them on a military basis, for example. Why don't they share some of their high intelligence secrets so that we are a bit at par and there is some parity in global security? Why are we always picking and choosing, especially when it involves private players? In that sense, are we in a free market economy as it is? Are we in a socialist system? Are we pushing for a communist, or are we all just confused? Thank you.
That's a big question. Tracy, that, and we'll take one more here.
Thank you, Prof, for a beautiful presentation. I'm Solom Zinokeman. If I listened carefully, I think I heard what you were talking about in relation to lock-in processes. What you are actually saying is that the lock-in processes are the ones that are creating an uneven playing field. And I'm trying to look at it in terms of tenders, just contracts in relation to contract. And my question is basically based on a preferential based gatekeeping, because you spoke about gatekeeping. And often at times when you look at this in relation to contract, there's going to be a preference, whether one who they prefer who they must take in. So I'm trying to find how do we regulate that preference-based gatekeeping?
And then the last one from the
Thank you, Prof, for the presentation. I just wanted to ask in terms of some of the challenges that were raised, especially when regulators do their job and they are threatened by sanction and all those type of stuff. I want to know if maybe we should begin thinking about an international regulatory body that can be able maybe to pronounce something that can be enforceable globally to avoid situations like individual governments or individuals in a particular country being targeted. And also, I'm also thinking in the perspective of some countries not having probably the resources to hold accountable those big tech companies. And if you have your EU or maybe in the US, they hold accountable that particular firm, that may not translate to that particular country because of the jurisdiction and all that. So can we think of an international regulatory body that can look at certain areas of competition law, especially when it comes to these tech companies?
Thank you. I'm Tembeletu from Genesis. So just outside of, I mean, we've spent a lot of time, at least in terms of competition law, and just my own background in understanding what, you know, the intricate balance is to intervene or not intervene. But it says a lot to me that outside of the experience of competition law, and particularly from a South African perspective, there's little less that we do know in terms of what other laws are possible to almost mitigate what you've all termed in a way this abuse of economic power that's playing out. And we've seen from your examples with the UK and the DMA and all the others. And I'm just interested in one, the idea of the difficulties that competition law faces in terms of onus and standards and economic evidence. Is it a similar difficulty seen outside of competition law? And I ask this as a non-lawyer, obviously. And whether is that perhaps a different way to almost think through how else can you better mitigate or control these issues that you're worried about without falling for the trap of competition law being almost the silver bullet to solve these market-wide dynamics we're worried about. Thanks.
Thank you. Thanks, Temeletu. That's a very good question. In fact, when you were asking it, I had a recollection of the Facebook WhatsApp merger. Some of you might remember that was an international merger, and it was notified in South Africa, and there was a concern raised, in fact, by the tribunal, saying, why are we approving this merger? And, you know, well, the rest is history. You can see what's happened. WhatsApp is no longer WhatsApp. It's WhatsApp with Facebook. And the minute you talk to someone about an umbrella, you see all these ads coming through on your Facebook chat. But what I discovered in discussion with a UK regulator was they had imposed conditions on that merger. And those conditions were about sharing of data and a restriction on that merger. So it's an important consideration to bear in mind when you're looking at big tech and data, because that's when services that you want to subscribe to do not remain service that you want because of this, you know, a non-restriction of data. So something to bear in mind, but a very good question. And I think I'll ask Eleanor to start with that. The question is, what other laws could we use to regulate big tech power? And what is, you know, is the issue of onus something that is creating a problem for us in competition law?
So clearly, onus does create a burden, and to some extent, it's a necessary burden for due process. So we don't want to just forgive all burdens. You know, I'm not sure what lessons can be drawn from other bodies of law, and it's almost for sure that other bodies of law face exactly the same problem. And I do think that in dealing with the problem within competition law and adjacent areas, going to an ex-ante system was a logical step. That the problems were that you have to litigate with so many resources every time, market power in effect. And if you can separate out and only have to deal with you have your gatekeepers, which may not be easy to get and get qualified, but then you have them, and then you can impose these duties. But the EU is finding lots of problems in operating this system also. It also is expensive. It's not as simple as it looks. So nothing is as simple as it looks. And I don't think that there is a really good answer. I think the adjudication system, the case-by-case system, maybe within a particular system, you can have more shifts of burdens of proof, and we have to focus on that. Another thing that we have to focus on is trials within a reasonable term of time. And another thing that we have to focus on is there have been, I want to say, shenanigans of some big firms that hold up the trial, that hold up the day of judgment, that put out every question as if it were a serious question when it's not. The court in the Google liability case said Google did this, but I'm just not disciplining them now. I think that maybe we have to have judges discipline companies more and being stronger. Because I think that the defendants, big pocketed defendants, are imbalancing the litigation process in a very detrimental way for getting justice.
Thanks for that. Any other questions that we haven't dealt with? Please, we can have a discussion over drinks, especially the broad questions, whether we are socialists, capitalists, confused. Confused, definitely. But I think that the one thing I wanted to say, Timala, to maybe have a discussion with Vicky Bronstein. She's dealing with data protection, and maybe that law could be looked at for some of the protections that you're thinking of and ways in which to control big tech's ability to monopolize itself. So I want to bring our session to an end, and thank you everyone for a very interesting discussion, but I want to hand over to Tracy, who will, thank you so much, Tracy.
All right, so thank you everyone. I think that this has been a great session, and the panel deserves a round of applause. Really do. So I'm not a competition lawyer, y'all. I'm a mining, environment, water. So I'm not going to conclude with some earth-shatteringly amazing insight about competition law, but I am going to leave you with an insight. So in the past month, I've been preoccupied with thinking about the future of the MI and what the MI has done in the past. And the MI has certainly done, MI's Mandela Institute, by the way. It has done a lot of good work on trade, on competition, the economic constitution, labor, access to knowledge. Colleague Sanya sitting there. And I've been reflecting on, what kind of holds it together. What coheres, what's the thematic glue going forward? And Eleanor, when I looked at your slides last night, it suddenly struck me what that glue is. So what unites all these areas of work from our situated global south perspective is that they are all about addressing systems of extraction, about predatory systems. You can provide me with a good service, but you don't have to take my data. And it struck me that there's nothing, it's not actually too different looking at the extraction of our agricultural produce, our minerals, our water, our labor, our data, our ideas, without fair value. So all of these things are driven by a dynamic of bullying, intimidation, a desire to cover the field, which is a very gendered assumption. And I think this is what the MI is going to stand for going forward. So what will it take to address these systems of predation? I think, first of all, courage. Courage to stand your ground and not to be moved. To insist on rules of fair play, balance, proportionality, empathy, restorative justice, and reparative justice. And ultimately, a willingness to even embrace the bully, to understand the bully. So thank you for that insight, Eleanor. And if you want to join us on this journey in the MI Go Forward, please come, my door's open, come chat to me. Great, thank you. So just think, the drinks are outside, and Derek he wasn't joking, he actually did pay for the drinks. Well, yeah. They were, so I'm just going to be like a few minutes, just 5 minutes. So vote of thanks. Firstly, Bowmans, thank you very much for the catering. We really appreciated that. And then the other costs, Southern Centre for Inequality is helping us with the other costs, so that's also amazing. We want to thank our photographer, Sina Temba, who's been roaming and taking unflattering photos of you, which are no doubt going to be posted onto the World Wide Web. Signage, PIMD, parking, the cleaning of the MI room, Mor Bakhoum from the School of Law, and our security. We don't want to forget them, Sarah and Lucy. And then most of all, and she's not here, we have to thank Magda Janse van Noordwijk of the MI, who really brought everything together. So lastly, I just have some gifts for the panel, which I'd like to hand out from the MI. They are customized. You get something special, Eleanor, sorry, which I'm going to share with you because this is really, it is special, but hers is more special. So, yeah, and I'm going to open your gift. Sorry, Eleanor. What we have prepared for you is the Mandela Institute. Customized. Oh, wow. Oh, thank you. Oh, that's beautiful. I love it. Thank you. This is a bag made by a black, she calls herself a black radical feminist who runs a repurposing center in Sebokeng, Witwatersrand Extension, who truly is able to create something out of nothing. And this was made by her community sewing group. Without further ado, please go and enjoy the refreshments that are waiting for you.